We have specified the evidence we intend to rely on,
yes,
and we'll abide by that.
Okay.
And in the event that there's any further evidence, we'll notify the court in good time. Thank you.
Good. Yeah. Mr. Rebello?
Your Honours, we have completed the questionnaire at E, evidence, by supplying a separate attachment listing every document that we have produced. There wasn't enough space in this document.
Okay.
So we've done it.
Okay.
And we abide by it.
Okay. Mr. Abdullahi?
My Lord, I associate myself with the sentiments by my learned friend Rebello, but I think this court probably needs to address a broader issue, which is the mutating nature of the petitions, especially petition number 4 and number 5. I mean, these petitions were brought in a certain form and with certain factual metrics. I think on Friday we were served with a huge document that will require both the IBC and my client to put in a further affidavit. We are now hearing that the fourth respondent will put. Can this court give us directions on the nature of the petitions the respondents are facing? We need to face a single petition, not a petition that mutates as time goes by or as increases as we reply to those petitions. And I think it will have an impact on the hearing of this matter if you allow the petitioner every time we reply to them to look for more evidence or to fish more. This case will never be heard.
So,
yes, my Lord.
What about evidence?
The evidence, when the petitioners thought that their course of action crystallized, they came to court with a second petition. We answered that petition.
Yes.
I think it's in the nature of these cases that a party normally puts in a further reply and affidavit, but we must have a time frame when those issues come to an end. And I think there's a danger that those issues may not come to an end, because frankly, I don't think the two petitioners know what their case is about.
We all thought, or we were convinced that that issue will come to an end today.
I hope so, my Lord.
Yes, okay.
I hope so.
All right. Mr. Ngatia.
My Lord, I think those comments are unfortunate. The further affidavit filed on Saturday was in response to their affidavit and was answering the very issues they raised with their documents, which they didn't serve up to Saturday. In fact, the documents have been served after we have responded. And that was our final response. And in addition to that, looking at the rules, there is no limitation on providing further evidence with the leave of the court if that evidence is relevant. So I do think that my friends should treat this matter much more seriously than those casual comments.
With respect, Your Honours, if I may just be given one moment, because the affidavits were served on us as IEBC. They were served very late. We had to work very late over the weekend to try to get them responded to. We've got the replying affidavits. We are in the process of filing them. But if
today, I hope.
Today, yes.
Yes.
And if the court would now direct whether it wants or needs any further affidavits.
We'll do that at the end of the day, because I think it will be premature now to...
Yes, we're getting these affidavits and documents being served on us so late, it's becoming impossible for us to coordinate and to respond to them within a reasonable time. And what we would like also, if I may suggest at this point, is if the court registry could supply to us a listing of all the documents which it has received as of today, so that we know whether we are on the same page.
Okay. Mr. Gatia?
Yes, my Lord. I apologize. I'll be the bearer of also bad news. The position is as this, my Lord, because it's important that this court is aware of it. The petition number 5 raised concerns about 34 electro areas. 34 electro areas. We responded to those electro areas. We made a complete response to it. The merits or sufficiency is now a matter in your hands. On Saturday, another affidavit going to about 900 pages, was filed by petitioner in petition number 5. It raises issues regarding 122 electoral areas, new electoral areas. We were served with that affidavit this morning. Mr. Ken Ogeto was served with that this morning.
Does it concern the application we're going to hear in the afternoon?
No, it is now about the evidence.
Okay.
Because we are on the paragraph dealing with evidence. I raise this, my Lord, because it's not just mutating, it's a metamorphosis. Here is a fact situation that was raised by the petitioner, as the petitioner is entitled to. We respond to it. Another new fact situation is raised. I say this, my Lord, because at the appropriate time, I'll seek leave for this honorable court to determine whether new complaints can be raised in this honorable court, entertained by this honorable court, after the time period has expired. But that is only number one. Number two, which is now of immediate importance, is that we cannot say that the evidence is before you. I am now formally seeking your leave, my Lord, to respond to the new 900-page affidavit, to respond to the issue relating to 122 electoral areas. And even if I were to work until midnight, the earliest I'll be able to file a response to it will be tomorrow late afternoon, if the registry would still be open. So, for your purposes, my lords, on evidence, what we had filled out on Saturday with my team is incomplete, because there will be that other response that we are now duty bound to make. But we'll make that response without prejudice to a fundamental question, whether the petitioner in petition number 5 can be allowed to mutate or his petition to undergo metamorphosis as a response is made to it.
I think you should respond to the affidavit as you have said, and we will definitely hear you on that preliminary point tomorrow at some point.
Very well.
Okay, you say you will do it by 2, so...
No. Late afternoon, my lord. Late
Today?
Afternoon. No, tomorrow.
Tomorrow?
Tomorrow, late afternoon. No, Mr. Ogeto is saying it's may not...
Because we just have... Today for pre-conference hearing, and we can take up some matters tomorrow as well, but that will be it.
We'll do our best, my lord, but I do not see us being able to complete it today. There are 122 new electoral areas. If they had been raised initially, would have had an adequate opportunity to respond to them. But having said that, my lord, let me now go to the next point, which is general, and I think it covers everybody. I come from the school of thought that a litigant is perfectly entitled to raise whatever allegation he wants to raise. But there has to be a limit to when those allegations are to be raised. Equality of arms, fairness in a trial require that timelines are set. If the petitioner in petition number 4 also wishes to raise any new thing, they should say so, and a time period agreed, so that I don't want to ever come before you, my lords, and apply for adjournment. Once we have agreed on those ground rules, that the time for allegations is over, time for response is also over, we now engage in the more meaningful exercise of processing this petition, consolidated petition, to a very quick determination. Thank you, my lord.
Thank you. Mr. Keegan?
My lords and your ladyship, we were also served with a 900-page further affidavit by the petitioner in petition number 5, and we would also need time to respond. My lords and your ladyship, it is our view that that affidavit distorts the issues that had been identified and the scope of the issue of testimony and evidence that would be adduced, because we now have to address new issues that have come up this morning after we had filled the questionnaire that the court had asked us to fill in response to the scope of the case. Lastly, my lords and your ladyship, on our part, for the fourth respondent, we would pray that you determine the question of whether or not that further affidavit is properly before you and whether it deserves to be responded to in view of the timeline within which the petition and the full scope of the petitioner's case should be met before we engage ourselves in the laborious task of responding to the 900 pages. We would very much pray that you give us audience on that issue.
Will your lordships permit me to say one thing?
Yes, we just put our heads together. Mr. Gatia and Keegan, I think at 3, if you're ready, you could argue that issue so that we give a ruling on it.
Thank you.
Before we subject you to replies, because what I hear you saying is that you want us to decide whether that affidavit is properly before this court.
We'll be ready. We'll be ready at 3 o'clock, my lord, as you have directed.
Okay.
My lords, I don't know whether it is now I would say so or at 3, but I would still say one thing just now, that the advocates for respondents are making the petitioners, now that these matters have been consolidated, to appear as if they are responsible for the change.
We haven't even ordered on consolidation. We had arguments and we said,
yes,
we're coming back, because if you remember, there was also a suggestion that although petition 3 will be heard with the others, but it's a standalone.
Separate, yes, my lord. But I'm saying that we are not responsible. Actually, it is the Independent Electoral and Boundaries Commission that has been so slow in providing information, even when it has been sought administratively before. So they must be responsible for the consequences of that being slow. 2, perhaps your lordships will consider this in the afternoon, that my colleagues seem to be mixing 2 things, issues and facts. The new affidavits, and I must confess I've not read the 900-page affidavit, I've not seen it, but if it is raising new facts, if it is raising facts that relate with the issues that have been identified in the petitions, there is nothing wrong with it. If there are new issues which would have required to be part of the main petition, that's a matter that can be distinguished in the hearing of the application rather than engage in any possible side shows. I'm saying this with tremendous respect, my lord, because time is of essence. The petitioners need these petitions to be determined quickly. I do not think that this court has more time beyond this coming Saturday to deliver its judgment, or to at least to render a decision. Therefore, we must be minded that matters that are intended to reduce the timelines for argument must be restricted and limited to the bare minimum. Thank you, my lords.
Mr. Ahmed, sorry. Yeah, it's okay.
I think that order you made should equally apply to the first and second respondent. That is the chairman or the returning officer and IEPC.
Everybody will be asked to.
Because
yes,
I think it's a very important issue, as you rightly say, that the petition we have facing now is not the one that was filed when my learned friend filed petition number 5. And I think we will argue that this afternoon.
Yeah, okay. Is that okay? I didn't ask you, Senior Counsel Oraro, is that...
It is okay, we should argue it, because what is happening is my learned friends are attempting to avoid their obligation to address the issues raised in the petition. The issues raised were the issues of tallying and the issues of verification. They then filed a response which was served on me on Thursday evening, confirming how correct their tallying and verification was. We have filed an affidavit from their documents, which we were unable to get without court order. In fact, we had to go to court to get an order to get those documents, and the final copies of those documents were served on us on Saturday. What we have done is annex their own document showing how their tallying was. I don't know how that can fall out of the petition, but we'll address it fully when they put in their case this afternoon.
Sure.
Yes.
Sure. Okay. I think on matters of evidence, I've gone through everybody, right? Maybe at this time we need what is left. Shall we discuss the management of time now? Not yet. Yes, okay. Okay, let's recap. So at 3, we have some rulings to deliver, but we also hearing 2 applications, the way I understand it. Your application and then Mr. Ngatia's application, 3. I think that's it. That's it. And you're also meeting, I think, to agree on the issues, and Senior Counsel Gatia is going to buy all of you lunch. So we then adjourn until 3. All right.
Identify the issues.
Yeah.